The judicial system of the United States, federal and in most states, is not worth a dime. More than 90% of the federal and state judges are powermongers and power freaks. More than 60% are outright dishonorable, biased and have no sense what justice is, and in total they are running a mockery of the judicial system of the good USA. They are dishonest in performing their jobs to different degrees. They have no integrity, thus they deserve no respect. They are making the judicial branch one of the most oppressive systems in the world. Judges are taking advantage of the respect of the majority of the citizens to the laws and running a mockery. I shall expose to you, the honest and hard-working citizen and taxpayer of this good country of ours, in a series along with the solid proof in a simple way, as it can be demonstrated.
Here is an actual case filed in a California Superior Court. This is a demonstration of a judge who came in to hear a murder, a motion. I appeared by telephone. Said judge was called from his courtroom to hear said murder. Said judge left his courtroom to the courtroom where the hearing was to take place, and as soon as he sat he called this case and in less than 2 minutes made a ruling without reading the moving papers or opposition or reply. A lot of judges do not read the legal papers, though this incident takes the cake. You will see and hear how things went on in this case. You judge for yourself the honesty and integrity of said judge and the judicial system he works in. I filed a motion for reconsideration, as you see and hear it. Plaintiff hereby requests an honest and conscientious reconsideration of the ruling of May 5, 2011 based on new facts which were discovered by plaintiff after the hearing. Plaintiff requests a reversal. Declaration of 1. I and the plaintiff in the above entitled case. 2. I have personal knowledge of the following facts, and if called upon to testify I could and would competently testify the same, as stated herein. 3. I confirm the absolute fact that my court case file never left the courtroom that morning ever. 4. Obviously Judge Nishimoto could not and did not read defendant's murder about 90 pages, nor did he read my request to strike defendant's murder, because it is untimely and violates CCP 1005B, 5 pages, nor did he read defendant's reply about 20 pages. His ruling was solely a prejudgment. I declare under penalty of perjury of the state of California that the foregoing is true and correct. Executed on May 7, 2011 in Los Angeles County, by plaintiff and affiant. Affidavit of actual bias and prejudice on the part of Judge Kerry Nishimoto in favor of defendants and against plaintiff, CCP 170.1 and CCP 170.3, 1. I and the plaintiff in the above entitled case. 2. I have personal knowledge of the following facts, and if called upon to testify I could and would competently testify the same, as stated herein. 3. On May 5, 2011 I appeared by court call for status conference and a demurrer filed by defendants. 4. I refused to stipulate to the pro tem attorney who was hearing the matters on calendar of May 5, 11/5. Judge Nishimoto was called and came to Department 1 to hear my calendared matters. I heard the announcement by the clerk of the judge's name, presumably, as he sat down. In less than 1 minute he called my case. Defendant's counsel announced her appearance and I did too. 6. I confirmed the absolute fact that my court case file never left the courtroom that morning ever. 7. Obviously Judge Nishimoto could not and did not read defendant's murder about 90 pages, nor did he read my request to strike defendant's murder, because it is untimely and violates CCP 1005B, as explained in request to strike said murder etc. 5 pages, nor did he read defendant's reply about 20 pages. 8. Perhaps he read the so-called research attorney notes, which usually includes proposed disposition, or spoke with the pro tem or read his proposed disposition before entering the courtroom. 9. Judge Nishimoto definitively did not read the above-mentioned documents, nor independently or impartially formed a disposition based on reading said documents. 10. Therefore the ruling he made that day was based solely on bias against plaintiff, as he asked me some questions not related to the murder or the status of this case. Also, he made his ruling solely based on his prejudice against plaintiff, who is improper, and in favor of defendants who are represented by an attorney who, by the way, did not speak about the merits of said murder period. 11. I challenge Judge Nishimoto to give us the legal reason as of his ruling and must honestly tell us under penalty of perjury that those reasons were formed before the ruling and said reasons were based on reading all the documents mentioned herein above. Apparently, he absolutely cannot. 12. In doing so, Judge Nishimoto violated the rules of judicial conduct and the oath he took for his office and the trust placed in him by the people of this beloved state, who expect judges to be unbiased and not prejudge motions and do not come up with decisions based on notes of attorneys. Judges are expected to be totally independent, impartial, and make decisions solely based on law and facts, as presented to them on filed papers. It is the duty of every judge to read the papers filed in any motion. I do not want to expose that flagrant intentional wrongdoing in a news conference or on YouTube and or other methods of broadcasting, though I am tempted to do so to make the people know what goes on in courtrooms in this state and perhaps in all states. I declare under penalty of perjury of the state of California that the foregoing is true and correct. Executed on May 6, 2011 in Los Angeles County by affiant. On May 6, 2011 in Department 1 of the above entitled court, defendants to murder on the first amended complaint was heard by the Honorable Judge Kerry N. Nishimoto. Plaintiff appeared pro per. Appeared on behalf of defendants. In their demurrer, defendants contended that plaintiff had failed to state a cause of action, and that his claims were barred by the statute of limitations and res judicata. Having considered the papers presented and the oral argument of, and for good cause, this court adopts the reasoning of the defendants to murder, and it is ordered that defendants to murder on plaintiff's first amended complaint be sustained without leave to amend, and that plaintiff's entire action is dismissed with prejudice. Dated, Judge, Superior Court. Superior Court of California, County of Los Angeles, Southwest District 19486, Torrance Courthouse. Order of dismissal. On the motion of court, and pursuant to local policy and or local rules, it is hereby ordered that the within action is dismissed with prejudice as to entire action. Order sustaining defendants to murder on plaintiff's first amended complaint, dated, May 20, 2011, Kerry H. Nishimoto, Judge, Superior Court. Please notice that said judge did not know what local rule he is applying, otherwise he would have stated it. Stating local policy and / or local rules strongly indicates that none exist. Judge for yourselves what judges do all day long every day in most courtrooms. Also, he could not have signed the proposed order, otherwise he would be committing perjury.